This week, our focus will be at yet another distasteful happening in our notoriously non-transparent real estate sector, that of developers defaulting on their loans to banks and financial institutions, loans which they have taken against projects already sold to buyers. And more often than not, money is taken from buyers without a proper buyer-seller agreement, and sometimes money is taken in the names other than the escrow account where it is supposed to be. We've got Vinay Singh, property expert, and Uday Vavikar, senior advocate, joining in to take this debate. But we've got a buyer with us, Amit Khurana, who actually bought a property recommended on the property show last year and is right now quite upset with it. Amit, go ahead. Tell us what really happened. It's an Orbit Corp property that was recommended, Residency Park, isn't it?
Thanks, Manisha, for taking up my query. Yes, as you rightly mentioned, in this case, I believe there are both things are true. One, while the sale was being made, there was no disclosure by the builder stating that these particular units are under a security to LIC Housing Finance.
Right.
And the second one is the payment was not taken into an escrow account as per the agreement, which obviously I got after paying the money.
Right.
So now the status stands is that, the property is now possessed by LIC Housing Finance. So I just wanted to know what is the status as an investor in this property, and, what is the remedy?
Okay, I'm going to first toss it across to Vinay. Vinay, clearly, I think the company, look at this. I mean, what do you do? The real estate industry says, don't bash us. Media's just got its job of bashing the real estate industry. Orbit Corp, a listed player. Orbit Corp, run by Harvard-educated Bits Pilanian promoters. Orbit Corp, with a website which talks big about corporate governance. And here you have a case. I mean, we feel sorry. Why are we doing this show? How are we to know that, LIC, they've defaulted on their loans to LIC Housing Finance? We only got to know in August when LIC Housing Finance came out with a public notice and said that, hey, we are repossessing this property because there's been a default. What do you do, Vinay? I mean, how do you support an industry where a listed player run by so-called professionals does this?
Well, this has always been a problem, Manisha. The so-called industry keeps asking for industry status, but it's quite clear that they are completely non-transparent about these things. Money for project A is utilized somewhere else, and so on and so forth. Now, in this particular kind of a case where they take construction funding, the lenders are very clear that the entire land as well as the flats itself are mortgaged to them, and each flat you have to take a distinct NOC before you sell it to another party. Also, the money that you get in terms of sale proceeds are to be deposited in an escrow account, and normally this kind of a clause is part of your agreement between the builder and the flat buyer. So this is something that the flat buyer also must need to check, that are these conditions there in the agreement, and if so, then he must ensure that the builder complies with it, because today LIC Housing Finance is going to tell you that this condition was not complied with, and therefore we are not concerned with this. Fortunately, he has an agreement. So since the agreement is there, even under MOFA, if it is not a registered agreement, doesn't matter, he still could enforce his rights as far as the property are concerned. So that is really lucky. But if he didn't have an agreement, it would have been a real problematic case.
Uday, what do you think really happened? I mean, here I believe they've taken a check in the name of Orbit Corporation Limited instead of the escrow account they should have deposited it in. So how easy or difficult is it going to be for Amit to recover his monies? I mean, that's again a very big question. Forget about, the fact that he would have he's lost, it's been an opportunity cost for him not buying something at the right price. It's also a question of how does he get his monies back?
It's a good question, and the silver line to this dark cloud is the consumer court. In fact, you will be happy to know that now consumer court has started giving...
UK, how is he going to fight a consumer court case? I mean, how does an NRI fight a case here in India?
No, today fortunately you have lawyers also in consumer court case. You have consumer organizations who are fighting the cases. He has to only send the brief to these lawyers, and they will take care. In fact, he doesn't have to appear at all. and 50% of the people are NRIs in most of the complaints. So that is not a worry. By power of attorney also he can file. So that can be a solution, but the consumer courts have heavily come down upon as an unfettered practice under section 21R, and also it's a deficiency of service, and therefore not disclosing, not putting into the escrow account. Fortunately, as Vinay said, they have got an agreement, and the best thing is consumer courts today are giving market value of that place so that he can buy another flat or similar flat in the same locality or the same size.
Okay.
So that these are the dynamic judgments which are coming in, and in Bhopal Internationals the National Commission says that if there is a interstate dispute between the parties, or if there is an auction sale, it is the responsibility of the developer to the purchaser, and therefore market value would be justified.
Okay, Vinay, will it help? I mean, I do know that Amit, I've been speaking to him, since we got his email, we've also been kind of distressed to know that a project recommended by us, and then something like this can happen to a buyer. It's a crisis of trust for us as well. Tell me, he's been connecting with a lot of other buyers. Do you think if they all came together, the case would be far more stronger, or do you think you should fight an individual case?
No, absolutely. It is always better to collect more people who are similarly placed, because then as a group it becomes quite clear that it is not that there are so many people who have been impacted, that obviously the builder has done something wrong. And I think you have sufficient evidence in this particular case to make out a case for fraud as well, because not depositing it there or not disclosing it to you beforehand is clearly fraud. So here is some opportunity for them to even press for criminal charges, which would definitely put pressure on the builder to in some manner settle this whole thing.
Fair enough. Okay, so that's Amit Khurana. Sabir, I know, I read his mail and both of us were, so distressed about it, that how can this happen? And what do you do? Was there any way for Prop Equity to have found out that they were defaulting on their loans before August, till we had that public notice in front of us? Because really what you do is look at the market, isn't it? And cull out good projects within that market. Don't recommend new projects because you don't know whether the person will complete it, promoters will complete it. We've been warning that that's a big problem with developers as well.
Well, there is no way in hell that you can get to know that if a developer is going to default. This is standard normal practice that in India, if you have to take a project loan, you have to pledge all the apartments to the bank, because what is the bank just going to do with the land?
So that happens with every project?
With every project. So this
So
is the
what
norm.
is it in the sale agreement which should be then built?
The sale agreement says that you have to build the flat, and it's been secured to the bank because the bank has given you construction finance against it, whether it's given it through the retail lender or directly as project finance to the developer, but it's the developer's responsibility to fulfill his financial obligation towards the bank.
Right.
In this case, that is what has not happened, and that is what has led to the LIC declaring them as NPA and then going after them, which is not happening in a normal course of events at this point in time. But trust me, most of the loans of all the developers are being restructured. If banks were to take steps like these, half the developers and half the projects will stop.
Okay, so there was a change of guard at LIC Housing Finance where the new head decided that, look, I'm okay to take NPAs in my books, but I will not restructure loans which are dragging and where I feel that the promoters don't have the capabilities of paying back. So unfortunate, but yes, it's happened. And not just one, there are more. We've got Mahendra Parmar also on the phone line with us with a similar problem. Mahendra, go ahead.
Yes, so thank you very much for Meenakshi Natarajan. I am speaking from Bahrain. I have purchased a 1 BHK flat in Hiranandani, Hirpo, Panvel, and paid all the money except against the possession, and I am holding the power of attorney. I have came to know from the Hirpo PLC UK, and that the Tata Finance and various banks, including the Punjab National Bank, file a winding up petition against the Hirko Hiranandani.
Okay.
Bank have put nearly 500 acres of the land and even the building for sale. The notice for sale has been served on the Hirko by the Punjab National Bank.
Right.
In view of the above, what will be the status of the existing flat owner to whom the letter of allotment has been issued. Is the purchaser of a property on sale will honor the letter of allotment, or our interest will be protected?
Okay. Uday, now this is even trickier because the gentleman here does not even have a sale agreement. He only has a letter of allotment. He's bought through one of the distributors. What does he do? I mean, Sunny Vista Realtors, this one seems even trickier, isn't it?
Most of the developers are doing this trick, but under Maharashtra Flat Ownership Act Section 4, and is lucky that is in Mumbai and in Maharashtra, Section 4 says that the promoter developer, even if he takes 1 rupee, has to enter into an registered agreement. So Hiranandani has defaulted MOFA here. He can have a criminal case. Of course, more than criminal, the best for him would be, as I always say, a case before the consumer forum. He can file a case before consumer court where an allotment letter can be, are considered today as a concluded contracts. It will be a deficiency of service for not entering the registered agreement, and he can definitely ask for refund and compensation or the market value, as I said, alternatively, or even the possession in an alternative of the alternative flat if he is going to deposit the entire amount with the court. And similar judgments have come. He has a ray of hope. Not to worry, there is an forum where he can fight for, and it is an effective forum because many builders have gone to the jail for non-complying the orders of the consumer fora. So there is a hope for him. Not that he doesn't have a hope just because he has an allotment letter. In fact, in Paranspe Builders, such a auction sale was stayed by Consumer State Commission, where many consumers went as a class action petition and stopped the auction, which was not properly conducted as their interests were involved, and certain portion was withheld for the payment, and that property was vested with the collectors. So there are a lot of rays of hopes for him, and of course he can go for civil court, but that will be a little difficult for him because there is no registered agreement.
Alright, we've got a similar question from Akif Samson as well, Vinay, before I toss across for both these solutions, where Akif has written in, I've invested in 2 apartments in the Herco Panvel project 2 years back. Construction has neared completion. We've come across many articles in the newspaper regarding the debt by Herco. So he says that these are really tense moments. We would like to take action immediately. We've paid 90%. What is the fate of this project? Will I ever get the flat or the money? So this entire Herco Hiranandani controversy, Vinay, has, really one is wondering, this is a very well reputed group. One would just go and buy, but now you have a situation where Hiranandanis say very clearly we are no longer involved with Herco, but the bankers say, I'm sorry, we will look at all properties and we will have to recover our debt. What does Akib do?
See, Manisha, we have always mentioned on this show that you try and ensure that you follow the law. Now, were the flat buyers to have insisted upon having the registered agreement as per Section 4 of MOFA, 2 things would have happened. Their rights would have got defined. They would have got a right in the property, which today, if you don't have an agreement, you do not have. And the third most important thing, under Section 9, the builder would not have been able to further mortgage either the land or the flats without the flat buyer's consent. So by not insisting upon the agreement, you have exposed yourself to all these risks, which in my opinion is not necessary. So you should insist upon proper documentation. Now, as I told you, once the lender does construction funding, he would mortgage everything and just release give NOC on a flat by flat basis. If you go to Punjab National Bank's website, they have listed out 383 flats where no NOC has been obtained and the monies have not been deposited in the escrow account. And if these people do not have agreements, they do not have a right in the property itself. So this is going to be the tricky part, but the good part is that since you are such a large group, if you get together and you approach the consumer forum, as Uday rightly put it, that is your best chance because you get great judgments coming from there. So then you can fight and say, listen, we have paid the monies and it was the builder's fault for not having made the agreement. Please make sure that we get the flats that we have booked or something equivalent in terms of market value.
Vinay and Uday, thank you very much, gentlemen, for taking this subject on this show. Important one, and also an important learning, I think, to all you viewers out there, that please register your sale agreement. I mean, how can you just be sitting on a letter of allotment? Please get into a buyer-seller agreement, register it. You will have rights at least to protect yourself from any defaults which the builder or developer does later on, which could put your property in jeopardy. And right now, I think Consumer Forum, as it's appearing in all these cases, is your best bet, and class action, which essentially means get together with other buyers to strengthen your case.